Hi, this is Lee Phillips. I'm an attorney and I want to talk about wills for 2 seconds. The question is, do you need a will? And the answer is it depends. If you have a very small estate, very limited number of people that you're going to distribute to, then maybe you don't need a will. We can go down to the bank and we can put what's called a POD, a pay on death notice on the bank account, and then when you die, that bank account just goes to whoever you've named as the beneficiary, the individual who gets the POD account. If you've got a piece of property though, a house or something, you probably do need a will, because I don't really want you to go down and put your kids' names on as joint tenants, because as soon as you put the kid's name on as a joint tenant, then that child actually owns part of that property. If the child doesn't pay their taxes, or they get divorced, or they get sued, or something else happens, there's a good possibility that you're going to lose your house. And that's not a good position for mom to be in. So before you put anybody's name on a deed, we got to think twice about that. And there's a tax issue with it in addition. It's a gift when you put somebody's name on a deed. When I receive property because of a will or even no will, then the property gets a certain tax treatment after you die. That does not occur if you put the child's name on the bank account or on the deed to the house. That's a gift, and they have to take what we call the original basis. So there's a tax issue associated with it. So use the will. The problem with the will is it has to be probated. Well, that's the advantage too, is the court manages everything. If you want to avoid probate, you're going to have to use a living revocable trust. Now, even if you have a trust, you're still going to have a will. It's a little different type of a will. In the trust, we have what's called a pour-over will, and it pours everything over into the trust when the individual dies. If it's not already in the trust, then it pours it all over into the trust so that the trust actually makes the distribution to the different beneficiaries. If it's a testamentary will, then we're actually going to distribute property in the will. It says who gets what and that sort of thing. Like in the movies, they read the will and decide who gets things. The will allows you to transfer property when you die. It's the process that our society uses in order to clear title, to get people into bank accounts, to make sure that somebody doesn't take advantage of the estate, the assets of the individual after they've died. It requires court supervision, so we have to file the will with the court. We have to get the executor or executrix, or the personal representative, whatever you want to call them, named as someone who can manage the estate. And then the court supervises what they do. But that assures that the creditors are going to be paid, that the wishes of the individual who died are going to be met, that nobody's going to cheat, steal estate stuff, basically. Now, if you've got a trust that's defined in a will, it's actually within the will. The top of the paper says will. That's called a testamentary trust. I don't think you want one of those because it's expensive to set up and you still have to go through all the probate. The living revocable trust avoids the probate. So, wills, yeah, they're a critical part of your estate plan. You need one, but you need to understand when you need a pour-over will and a living trust, when you need a testamentary will.